係請局方入嚟。好啦，我哋開咗咁多次會咧，我又唔逐一介紹啦。
All right, I don't think we need any introduction. So let's get started. Item 1, we accepted the administration's proposal to first scrutinize Schedule 10 of the bill. So we will start from Clause 94, subsection 8. In other words, that's page 423 of the marked up copy. 423, have you got it? So we are starting from subsection 8. Yes, thank you. Yes, we are on subsection 8 on page 423 under subsection A. The chairperson may determine a review or an application as a sole member of the tribunal, and B, the application is an application to the tribunal under Section 98 for an extension of the time, or under 1C, the application is an application to the tribunal for a stay of extension of a specified decision. And then 424, Section 9, that's privileges and immunities, except as otherwise provided in this ordinance, the tribunal, the chairperson or ordinary members, and any party, witness, counsel, solicitor, or any other person involved in the review have the same privileges and immunities in respect of the review. No questions. Please move on. Then we'll go back onto page 301. Last time we were on 115. So we'll start with 116 now. So 116 is part 13. Wait a minute. Wait till after members have got it. So it's on page 301. So after looking at Schedule 10, we are now on page 301 again. That's miscellaneous Division 1 immunity. Clause 116. Please move on. Yes. The new 116 is in fact an update of the existing provision, Section 55A under the Insurance Companies Ordinance. So that's an immunity on legal liability, and it also provides that for any person who is performing in good faith or purportedly performing a function under this ordinance, then there is no need for him to show that any civil liability. But then under 116, 2A and B, it provides that this immunity does not apply to an auditor appointed or an auditor or actuary appointed. So that's an auditor appointed by the IIA. Regarding 116(1), a person is not civilly liable for an act done or omitted to be done. So is there any difference between the English and the Chinese version? 116(1). Is there any difference between the Chinese and the English version? Chairman, in English is omitted to be done. So all along the Chinese version has been like that. So there is no difference whatsoever. So in simple terms, there is no difference between the English and the Chinese version. So that's consistent. All along you've been using the same translation. Yes. Next, page 302, 117. In fact, it replaces the existing 56 under the old ordinance. It provides that if any person induces or attempts to induce another person to enter into or offer to enter into a contract of insurance, then he'll be held criminally liable. And then under 117(2), it also says that, well, the existing provision also has the same requirement. That is, a person if he causes or permits to be included in a document specified in this ordinance a statement which the person knows to be false in a material particular, then he will also be committing an offense, and the relevant offense will be liable to a $1 million fine or 1 year's imprisonment, or level 6 fine or imprisonment term for 2 years. So imprisonment term for 1 year? No, 2 years. Yes, Mr. Yu Si-wing? As we know, we have the trade descriptions ordinance, and there is one provision which is very similar to this one. And if anybody files a complaint, and then which clause will be invoked to punish the person, or will both provisions be invoked? Trade descriptions ordinance and also the insurance company's ordinance. Chairman, is very simple. The ICO will be invoked. In other words, if there is a complaint filed by the client, and if he wants to revert to the trade descriptions ordinance to charge that person, then what are you going to do? Well, the trade descriptions ordinance has exempted the financial services sector. That's why it will not be relevant. But then I'll have to go back and check. I'll give you a response later. But then I understand that the trade descriptions ordinance does not apply to the financial sector. In other words, the insurance companies and also banks will be exempted as well. Yes, initially the discussion was that in the financial sector there is already a regulatory regime. That's why if there is any dishonest means or deliberate attempt to deceive, then that should be left to the relevant regulator to follow up. That's why under the trade description ordinance, financial sector will be exempted. But then I'll go back and check and let you know. So the TDO is under the ambit of the C&E, right? So for securities and financial services, that should be under the SFC. Yes, the relevant regulator will be responsible. So for the insurance sector, they will also come under the insurance authority. So can you provide us with the supplementary information next time? All right, please move on. Next, page 303, 118. 118 replaces the existing 56A, and that provision provides that a person must not use the name insurance or assurance in the document, or to use any term that would give rise to the meaning of insurance. And also subsection 1 does not apply to any of the following: an authorized insurer, an approved association of underwriters, lawyers, and a licensed insurance intermediary. And also on page 304, an association that comprises mainly licensed insurance intermediaries or their employees, and that is formed for the protection or promotion of their mutual interests. And then 119 provides that except for specified circumstances, the person is not to disclose information obtained in the course of inspection, investigation, or disciplinary action. For any person violating this, then he can be fined at level 4. And then on page 345, subsection 4, it provides for the specified circumstances, and the conditions include: A. The information has already been made available to the public because of being disclosed in any circumstances in which, or for any purpose for which disclosure is not precluded, or the disclosure is for seeking advice from or giving advice by a counsel or solicitor or any other professional advisor acting or proposing to act in a professional capacity in connection with a matter arising under the ordinance. And then on page 306, C and D says that this disclosure is in connection with any judicial or other proceedings to which the person is a party, and the disclosure is in compliance with an order of a court or in compliance with a law or a requirement made under a law. And then clause 120 is to replace the existing 55. And It provides that if an authorized insurer incorporated or formed outside Hong Kong ceases to have a place of business in Hong Kong, then the IIA will have to be informed, and then the penalty is similar to the existing ordinance. And then 307/121 is a new provision. Here, it sets out the exceptions to the licensing requirements, so that for professionals, like under 1A, a barrister, or B, solicitor, or C, accountant and actuary, under subsection E, so they can provide regulated advice. But then the premise is that they are acting in their capacity as professionals, and they are giving such advice in such capacity, and also for the licensing requirement that's in D, G, and H. So that's about trustees, and also loss adjusters. So they can provide advice. For example, for loss adjusters, they can provide advice to the insured. Then there can be an assessment on the amount of compensation. Mr. Alan Long. Chairman, if I write a song and if the name of the song is insurance, and there can also be an attachment which is named, or if I make a film which is named insurance, then would that be breaking the law? So it's about the term to be used. Chairman, well, for the reference to reference, it's in the course of conducting a business. So if it's about an insurance business, but then if it's just the production of a song, then it has nothing to do with an insurance business, then that will not be regulated by this law. Any questions? Because 118 talks about the restriction on descriptions which are related to insurance business. So that's a description in the course of insurance business. It has nothing to do with cultural performances. All right? Still, I have a question about 118, bracket 1C and D. The way it is put here is that very commonplace, because you try to break down the word insurance and then you include all the letters here, and you use quotation commas to include every letter, and you said that they are not supposed to use that word or letters in that order. Is that very consistent with other pieces of legislation, or is it a specific way of dealing with that now here?
Under the existing 56A, it's already there. It was passed in 1983, so the provisions have been around for decades. Ms. Sitho, why did you do that in 1983? Because you were worried that people may do the spelling that way? But that means that if you use these letters in that order, you are actually writing the word insurance or assurance, and if you use such words to describe the business, your business, that means that you are suggesting to the public that you are an insurance company, but at the same time you don't get any authorization from the insurance authority. So that's the problem. So that's the way the provision was drafted. But if you are not using the letters in that order, and your name just happen to have these letters, then it's not prohibited. But concerning creative works, such as a song, but what about an advertisement company or a moving company? Can they use these words? No, not if they use the words insurance or assurance. But if the order is different, it's another name, it's another word. But if you are using those letters in that order, you are using the word insurance in your company name, that won't be allowed. We have seen some advertisement of moving companies? Can they register the name that everything is assured? Well, the advertisement would not be regulated, but if the company's name or in describing their business, they use the word insurance or assurance, that won't do. What if an application is received by the company's register and the company's registrar may not be aware and he may or she may not be aware of this requirement? Would the company's registry advise him against doing that? Well, I don't think anyone can plead ignorance of the law and then break the law. The company's registrar have to undertake its duties. There are so many applicants. But all I can say that this is not allowed under the ICO. If you want to incorporate the company, you would get help from a solicitor or an accountant, and there would be there should be advice given by the solicitor or the accountant. What if this is not a limited company? Well, if he gets a BR from the IRD, then the person will have the responsibility to ascertain this. Has there been anyone who has fallen foul of this rule? We'll check. Yes, there were investigations. So that was the commissioner's duty. Did you ever ask people to rectify their names? Well, it's actually case specific. Whether we will press prosecution or not is for the DOJ to decide. But if we notice that someone has done that, we would conduct our investigations and also inform the police. In the commissioner's office, whenever we have cases of a criminal nature, we'll ask the police to follow up. So simply put, there have been cases, and we have referred cases to the police. Whether prosecution will follow, we will look into the case after the police investigation and then take up the matter with the Department of Justice. Of course, if the wrongdoer is an insurance company, then you are correct in invoking the ordinance. But sometimes the wrongdoer is just trying to give people confidence that his business is sound and reliable. But it's not actually doing insurance business. My concern is that with the words or words added to the description, you give people a misconception that this is an authorized insurance company or a licensed intermediary if this is passed into law. That's not what we want to see. We don't want to see that. So whether the business is related or unrelated to insurance, they should not make such references. Mr. Alan Leung, I thank the Deputy Secretary for replying to my questions concerning songwriting or lyric writing or filmmaking. May I be further assisted? I have been looking at section 118. You are talking about the person who is carrying on business in or from Hong Kong, in any business. Where do you find the reference to the part that the business must be related to insurance? And that is, you should be assured only for those who are doing insurance-related business will be barred from using the terms, the description. Well, it's not that the business must be related to insurance. Whatever your business, related to business or not, you are not allowed to use insurance or assurance. Because by using the terms, you give people a misconception that your company is either an authorized insurance company or in the future a licensed insurance intermediary. We don't want to have this misconception whether your business is related to insurance or not. In your name or in the description of your business, you are not allowed to use these terms unless you have the authorization by the commissioner at present or the authority in the future. Using my example, when I write before I write a song or before I publicize my film, I will have to get an authorization from the authority. That depends on your business, because that depends whether writing a song is a business. Because 118(1) is about people carrying on business. So if that's a business, you may have committed an offense. But if you say writing a song is not a business, then it's not covered. But if the act is a business, is regarded as a business, or if we are talking about the name of a company, then you may have committed an offense. That depends on the case in question. So that's why I've said that from time to time we've noticed that there are such instances, and the police will be asked to investigate. All right, that's clear. Let's settle this for the record. If you want to use these two terms, and whether you are doing insurance-related business, anything which can be understood to be business, should be subject to an authorization process, and you should play safe. In 1983, the previous ordinance was enacted. I don't want to challenge what happened in the past, but if you look at the rules for solicitors or barristers, no such strict rules are applied. For example, you don't prohibit people from calling themselves solicitors in the letters or barristers in the letters, SOLICITOR. So this is unusual. Mr. Yu Si Wing. Well, in the Chinese, you have people doing insurance business, or they're doing insurance business, or they are providing insurance. You're not allowing them to use the two Chinese words, 保險 meaning insurance. So how can you tell whether the term used is problematic or not? Chairman, I think if you are talking about providers of insurance service, you're talking about banks. Well, some companies also offering the service. Maybe there are companies selling the safety equipment. Maybe they are manufacturers of safe deposit box. So far, we haven't discovered any case that is caught under ABCDE. But if we know that they are actually referring to the manufacturer of the safe deposit box, which also in Chinese is 保險箱, and 保險 means insurance. Maybe they should also seek advice from the authority. But in recent years, I haven't discovered any cases of that nature. But usually the insurance service is provided by the bank. We understand this is part of the banking business. But if it's a manufacturer, so far their description hasn't been found to be problematic. But if you use the two terms, insurance or assurance, but you are not an authorized insurer, then in recent years we have encountered some cases, and we have also conducted investigation into them. We believe that this provision serves useful purposes. If the example quoted by Mr. Yu does come to pass, then perhaps we can provide written advice for making suitable changes, depending on the actual circumstances. This can happen. There can be companies selling safe deposit boxes. Because under B, you talk about not allowing the use of Chinese expression 保險 insurance, or the character 保 insure followed by the character 險 meaning risk. But since the company is not in the business of insurance, he may not know that he needs to seek the advice of the authority. Well, the authority can give a written consent in respect of individual cases. If we really have this case before us, and that they cannot use other terms, then the consent can be obtained. Mr. Yu, you cannot just look at small b. It's under bracket 1. If you just look at the two Chinese characters, 保險, you must read this together with bracket 1 when you apply the law. If you talk about safe deposit box or 保險箱 in Chinese,
it's safe.
So they are called safe deposit box rather than insurance box. So in terms of the Chinese terms, it won't give rise to anything to do with insurance. So it's not like taking out an insurance policy. So I believe that if you try to play with words, I don't think that will be the case. And if you want to seek the advice from those in the legal profession, whether or not they would take things out of context, that they would only be looking at subsection B rather than subsection 1, I don't think anyone would do that at all. If that is the case, then there is no need for the party to get the written approval or written consent from the IIA. Well, just now the chairman said that you will have to look at subsection 1. In fact, there is a way. So if you really have to use the word, if you really want to use the two words, then you can always go to the IIA to seek its consent on a specific case or a particular types of case to get its consent or approval. So the circumstances that you just referred to, if you think that it's not problematic at all, then he can always go to the IIA for approval. But then under the general circumstances, if you have not got this written approval or consent, then you are not allowed to use it. So it's like what Alan Leung just said. All right, if I just come up with a song called Long Live Insurance, or if I just make a film called that the Insurance Saga, then it's not a problem at all. All right, any further comments? Yes, Paul Chair. All right, I understand that there is a historical background to this. But I'd like to know that for anybody breaking the provisions resulting in the administration having to go that far in regulating this, because as some other members have said, for professions requiring very high qualifications, there isn't a similar practice. So what are the reasons why you have to go for such stringent requirements? Well, because this is a business entity, and it might mislead the public into believing that this is a licensed insurance company, and the consequence could be dire. So in simple terms, we have had such cases, and even now we have cases being investigated right now as to whether or not we will have to go to the DFJ for prosecution. That will be for later, but then as of now, we have cases being investigated right now, and the penalty is relatively heavy. And if it's not very clear, and of course innocence is not an excuse, it's not a defense, but then you will have to have sufficient justifications to impose such a stringent requirement in terms of policy. So in terms of the number of cases, how many cases have we had over the years? Well, we don't have a ready answer right now, but then for sure we have had such cases. And we have also conducted investigation, and follow-up action has been taken. So can you give us a figure later as to the number of cases over the years? Can you provide a reply in writing? Yes, I'll try. Any further questions? All right, let's move on. Page 308, circumstances under which licenses are exempted. Well, bracket F, and on page 308, anyone is prohibited from giving regulated advice through the media. And also 308, bracket 2, says that anybody, if he discharges any duties on behalf of a person, then he can be exempted from getting a license. And then 310, page 310, bracket 5, says that the Financial Secretary may by notice publish in the Gazette amend subsection 1. In other words, with regard to the exemption on licenses, these are the exceptional cases. So in passing, in response to the views from the sector, we'll be moving a CSA, which will be amending the exempted circumstances in 121, because the sector says that there are certain duties which have to provide some regulated advice, for example, for the insurance business, and also certain claims business or claims duties, and we agree that those do not require a license. That's why we'll be moving a CSA later. So you're broadening the scope of exemption. Yes. Yes, legal advisor. Thank you, Chairman. In the marked up copy on page 310, 121 bracket 5, it says that the Financial Secretary may by notice publish in the Gazette amend subsection 1. So first of all, I'd like to ask the administration to clarify this. Is this a piece of subsidiary legislation? And also subsection 1 is about exemptions or exceptions on providing regulated advice. So if this is a piece of subsidiary legislation or not, then members will also have to consider whether it should be in the form of a subsidiary legislation in making such changes. Who is to answer this? Chairman? On gazetting the decision is a piece of subsidiary legislation, so there is no question of members being kept in the dark, because whenever we table such a subsidiary legislation, we will have to first conduct a public consultation as well as a consultation with the trade. So under 134, it says that we have to conduct a consultation. So please rest assured that there will not be any such changes without your knowing. So when there is a consultation, it will be done in the form of a subsidiary legislation, and this council will be informed. As to whether or not we are going to move an amendment to the principal legislation, well, in looking into this, sometimes it depends on the development of the insurance industry, whether or not there will be more functions or duties, or whether we have omitted certain circumstances which even the sector might have omitted, or if there are some new job types which have to be exempted, and if that should arise, then I'm sure doing this by way of a subsidiary legislation would be more flexible. But then at the same time, there is no question of not consulting the sector and not tabling the legislation before this council. So that's our thought. So in the future, it will be easier for us to amend it. All right, please move on. Yes, Paul Chair. But I'll just double check with you on the circumstances, because 121(1)(a) prohibits the council from Roman letter 1 and 2. Maybe I haven't come across many such cases. All right, very rarely would counsel be used in this way. So in the legal professionals ordinance or legal practitioners ordinance, should you be using barrister rather than counsel? Yes. Thank you, Chairman. Thank you, Mr. Chair, for your question. In fact, for the word counsel, well, under clause 121, when compared to section 34M of the MPF ordinance, the term is consistently used. In that provision, we also use the term counsel. If I remember it correctly, in other pieces of legislation, we also use the term counsel. But then if you want to have a list, then we can prepare that next time. So under the LPO, the official name is is barrister rather than counsel. So when have you started to make that change? So can you give us a reason? And compared to other pieces of ordinance, would there be conversion or not, or inconsistency? Because there has been some argument about this term. All right, I'll provide the information after the meeting. Okay, please do supply the information to us. Yes, Ellen Leung. I'd like to go back to 118 because the focus is on any business. But then, Chairman, as you know, right now in this bill, what we are dealing with is under 3 capital letter A. There is a definition on regulated activities and also critical decision and also regulated advice. So we do have this new provision. So under 118, if the purpose is that if you engage in any regulated activities under the bill, or if you're making critical decisions, or if you're giving regulated advice, or under 3B, is that 3B? So my concept is very simple. So let's set aside any business. But then if you're talking about carrying on of any business defined as regulated activity and so on. So if you're talking about regulated activity, material decision, and regulated advice, then you cannot use the term insurance or alphabets in that order. So why can't that be done? Will that be something pretty unlikely to happen? Because it would attract a penalty under subsection 4, $200,000 fine, and also imprisonment term for up to 2 years. So this is not a light sentence at all. So if the original intention is not to regulate movies or song making or other businesses as described by Mr. U.C. Wing just now, then why have you not made it clear and without ambiguity? Well, 3A in itself is about intermediary. So that's about Schedule 1A. So all those activities are related to regulated activities of the intermediaries. But even if that is set aside, from time to time we do see cases in which the business might have nothing to do with insurance, but then the name has used the term insurance or 保险 in Chinese, which might give people an impression that there might be something to do with insurance, or it might be subject to regulation, but then in effect they might be involved in other types of business. And if they give people an impression that maybe this company is regulated, that's why they have a greater confidence, but then in reality they are engaging in other businesses, so that might be problematic. That's why if so you should not be referring to this if it has nothing to do with your business. And if you want to make that reference, then you will have to come to the IIA so that the IIA can take a look, and then it will give you a written consent. So with this escape route, we believe that for the other circumstances, you should not be using that name. So we have actually seen that case. All right, I've heard it, Chairman. So you are not trying to regulate any other businesses. Well, Chairman, as you have already instructed the administration to come up with a supplementary information paper, so can you do it in black and white, giving us all the detailed reasons? Thank you. All right, please move on. Page 310, 122. Offences by body corporate and partners. So if it's a body corporate, or if it's a partners, and if it's been proven that the controlling person or the director or manager or a partner in a partnership, or if it's done by consent or connivance, then that would be an offense. No question. Please move on. Yes, Sin Chung Kai. Right now, this is a general statement. Can you speak to the microphone? Of course. So this is a general question. Well, as far as banks are concerned, well, the law has been changed. So it's almost like the controller of a bank will have to do something to prove or to prevent you from committing crimes.
And now here, now let's say the body corporate commits an offense, and you are trying to find an individual to be responsible for that. And you have to prove consent or connivance on the part of the individual. The threshold is much higher. But if you look at the banking ordinance, because of Sarbanes-Oxley Act and the like, the bank has to institute a lot of things to prove that you have done this or that for compliance. Otherwise, you wouldn't be excused. So perhaps your colleague can make a comparison with the banking ordinance. This particular provision is very lax. Well, here's a general liability provision, telling the individual that you wouldn't be let off the hook if the offense is committed by the body corporate. Here we're talking about a controller or people with controlling responsibility in an insurance company, or the people in charge of an intermediary. There are certain positive duties to discharge. For example, some internal monitoring and checks and balances must be carried out, otherwise he will be liable. But here it's just an additional general provision, so that even if the individual is not a controller or people with control functions, the partner or the major shareholders may still be liable. But it doesn't mean that we don't have all the other requirements and obligations imposed, as suggested by Mr. Sin Chung Kai. In that case, when are you going to invoke 122? If there are positive duties imposed on the controller or people in charge, there must be one or two people in charge. But here you're talking about you are targeting the directors generally. Is there a difference between the two sets of requirements? There are positive requirements, and you are targeting specific people in charge, not all directors. Here you are talking about offences committed by bodies, corporate, and partners. He is switched on the mind of the Deputy Secretary. I still haven't got it. Mr. Sin is referring to Section 122, bracket 1. In the case of a body corporate committing an offense, if we have evidence that some individual has given the instruction, then that individual is also committing an offense, although the charge will be pressed against the body corporate. Under 1A, we're talking about individuals. If an individual gives a direction to for the purpose of committing the offense, then that individual is also liable. That's how I read 122(1), bracket 1. Mr. Paul Chair, I don't quite get the meaning of Mr. Sin. Is he trying to make it straighter or the other way around? If you look at 122, 4, and 5, bodies, corporate, and partners are subject to these presumptions. Anyone who has management duties will be caught. So they will have to prove their innocence by rebutting the assumption of the prosecution. I believe this is already very strict. I don't know whether if Mr. Sin is suggesting that it should be made even straighter. Thank you, Mr. Paul Chair's explanation. I accept his explanation. So basically, if you are in the management and you are participating in the meeting, you are caught. For example, the cases of wages in arrear committed by the ATV, the director, Mr. Yup Kapo, has been convicted for failure to pay wages. I believe the government is very strict about this. I understand 1224. When I read 1222, I hadn't read 1224.
我都想跟進翻頭先我曾經講嘅116。
I want to refer to 116. Acts and omissions. Now it's also found in 122. Acts and omission. One is an offense, the other is not. Can I be given an explanation on the difference? 116. A person is not liable, civilly liable, for an act done or omitted to be done. But for offences committed by bodies, corporate, and partners, neglect or omission can also be the basis of an offense. I don't think we should compare 116 and 122. 116 is about the employee of the authority or member of the authority. They will not be liable for acts and omissions done in performing a function. So that's what we call an act omitted. But 122 is about offenses committed by regulated people. For example, an intermediary has done something not in accordance with law, or has omitted to do something according to law, for example, failure to submit some documents. So an offense is committed in both cases. It's not suitable to compare the two provisions, and there's no question of inconsistency. But you're using the same legal terms. I just wanted to seek a clarification.
我頭先已經解釋咗，冇補充。
I have nothing more to add. Mr. Sin Chung Kai. 122 bracket 4. Director, manager, company secretary, or member of the body corporate. What do you mean by member of the body corporate? Another person concerned in the management. I don't understand member. I understand director, controller, manager. What do you mean member? We're talking about members of the body corporate. Why do we have this? We allow a body corporate to hold a license, and also a partner or sole proprietor to hold a license. Are you talking about director when you talk about member?
但公司嘅股東係咪一定有決策嘅？
主席，如果就住呢一個法團嗰個
In the case of a body corporate, a member is mainly about is the shareholder. Shareholder, not controller. Or if it's not a listed company, there are many shareholders. And look at China Insurance, there are many shareholders. We will look at the entire provision. We're talking about the member of the body corporate giving consent to the body corporate to commit the offense. It's not that once the body corporate commits an offense, the member will have a criminal liability. Well, we talk about the consent given by the member. Mr. Paul Chair. Bracket 4 is also talk about concerned in the management of the body corporate. I think the reply only cover half of that particular formulation. 123, section 123. Mr. Chan Kim Paul.
咪啊，陳健波議員。
而家有啦，謝偉俊議員講得好，即係好啱嘅，即係
Mr. Porcher is correct, but he's being nice. He asked whether it's really too strict. Actually, it's very strict. It's too strict. It means anyone can be caught. In the SFO, in the MPFO, to have similar provisions. If that's the rule, who dares to run a business. And also in 6, the person is asked to adduce evidence, rebut the presumption. That's asking for too much. Can we have the mic turn on for the legal advisor? Bracket 4 and bracket 5 are based on recent laws. For example, lifts and escalators, 600 and cap 618 with similar terms used. And also the competition ordinance, cap 619, we have similar provisions. But they are not about financial services, although the competition ordinance is the newest one. We have to be careful. But the nature is very different. So you are casting the net very wide. People would have a hard day just to pay for their lawyers, just to pay for legal advice or their lawyers. Mr. Sin Chung Kai, if you look at the banking ordinance, the reverse is imposed. The management has to carry out positive duties to ensure certain things. And even if you have done that to prevent offenses, you can still found to be to have committed offenses. So enforcement can be difficult. So there are two sides of opinion. Let's ask the Bureau to consider both sides of the argument.
I'd just like to add that at present, under the law, there is a very clear definition of a responsible officer. So he will have to come up with a set of policies or procedures to ensure that everybody will follow that set of procedures. And if he fails that, then he will have to be held criminally liable. But then for anybody involved in the operation of a company might be held liable. So there is a very large extent of uncertainty. Well, in actual operation, it might not be the case. But then if the IIA is to prosecute people haphazardly, then people will have to go to the court very easily, and the operating costs will be so high that it's very difficult to operate. And with such laws, it's very draconian. So the compliance cost will be extremely high. So are you trying to copy from the competition ordinance and other pieces of legislation? Is that necessary? Because you've already got a very comprehensive mechanism in place. You've got responsible officers who will be held liable. So why do you have to do this at all? Mr. Raymond Wong? In fact, under bracket 4 and 5, it involves a person. So are you referring to the persons being referred to in the above provisions? Who is to answer this question? So for the person concerned, are you referring to all the persons that are listed here? Mr. Wong's understanding is correct. Then why do you have to put it that way? So these are the persons concerned. So why do you have to put it that way? Because the bracket is not very clear, and that would be misleading. So people might have thought that it's the person being referred to before the punctuation mark. So there is no need for you to put in to put in the term the person concerned. In fact, it's a drafting tool. So it's like a definition, as Mr. Wong just said, is to identify the controller, the director, the manager, and so on. So at the time of the commission of the offense, all the persons concerned will have to be liable, blah, blah, blah. Do you understand what I mean? So you can put it the other way round. So I believe that what Mr. Wong just suggested might be feasible, but then the way we have put it, that's a very common drafting tool. So both descriptions would be okay, but then to include it in a bracket would be more common. But then when we write Chinese, we would just be referring to the earlier phrase. So it's as simple as that. All right, if you're referring to these persons involved, then you can just list out all the persons after the punctuation mark. Well, the way you put it is okay, but then in law, we try to make it as clear as possible so that there would not be any ambiguity. But then the way you put it here, that might give rise to some ambiguity. It has nothing to do with the main theme. It's just a textual improvement. Well, on top of what Mr. Chen and other members have said, I'd like to add this. Well, number one, for a body corporate, if the mask is to be taken away, then it would involve a very serious offense, because we don't want anybody to make use of the mask of a company to shield or to evade his responsibility. But then, for some Chinese restaurants, they might try to close and then a new one will open in its place. So we try to remove such corporate veil in order to prevent these people from continuing to commit further crimes. That's why there is a reason for us to do certain things, because generally speaking, why do we not allow this body corporate to be the target for enforcement? Why we are not allowing them to use a company or body corporate as a vehicle? Or else we should respect this too, because that would also reduce the risk in operation. So in this regard, do we have to impose this stringent requirement? Because if you look at the law here, in particular subsection 4 and 5, the assumption is that you don't really have to look at the individual crimes or acts, whoever is involved in the decision, but then still, if he fails to take action, then he will be caught. And also for shareholders and directors, if they are involved in the general management of the company, then it's assumed that they are already aware of this, and then they will have to come up with a defense. And as Mr. Sin said, for example, in some banks, if such requirements is diligently followed, then you might be able to prove that that assumption does not stand. But still, they will have to go through prosecution, and they will have to incur legal costs, and there would also be a lot of psychological pressure before they can prove their innocence. So is it really necessary for insurance companies, if you look at their operation, is there sufficient justification for this to be done? And also, do you have to err on the safe side so that you will have to remove their corporate veil, which would protect these insurance companies' operations? Who is to answer this question? As to the legislative intent, what is the emphasis? Chairman, I'd like to thank the comment by the member just now. As some members have said just now, here we are trying to strike a balance. We understand that, for companies' legislation, there is a basic principle that is Solomon versus Solomon. In other words, where there is clear proof that there are persons in control, and if they are involved in a criminal act, then they will be held liable. And in drafting this law, we have also made reference to some recently enacted legislation and how they are drafted. For example, for the two pieces of legislation that we just referred to, well, in 2013, when we approved the MPF amendment bill, we also used similar wording. As regards whether or not in actual operation we have detected many such circumstances, for example, behind the veil, if there might be a person in control who has involved very actively in such a criminal act, that's why we have to tighten the rein over them. Well, we can go back and think about it. But then what I'd like to say now is that after all, well, this provision applies to insurance companies as well as insurance intermediaries. So licensed intermediaries will be regulated by this. And at present, indeed there are some individuals setting up companies and there are partners as well as intermediaries being set up in the form of body corporates. That's why we have these provisions in place, so that if we are aware of shareholders who have or partners who have actively taken part in the operation of the companies, then they will have to be held liable. But then we'll go back to see if there is any room for amendment. If there are no further questions, then please move on. Sorry, speaker's not coming through. Please turn on the microphone for Mr. Sin. Well, I think the law is being amended. For example, the MPF ordinance, they've also enhanced the responsibilities here held by the controllers of any company. So if there is any change, it should not be lagging behind other pieces of legislation, whether it's the SFO or the MPF ordinance. We don't want to see a situation whereby after the enactment of this insurance companies amendment bill, we will be lagging behind in terms of other regulatory regimes. Mr. Chen Kin-po, I have to emphasize that we need to strike a balance, because we're talking about a specific piece of legislation and there are provisions in place to target individual acts. For example, for the chief executive officer or the person responsible for the agency will be held responsible. So there are already existing provisions in place. There is no need for you to cast a net very wide so that you can include everyone. I don't think that's appropriate. And please do not ignore such minor provisions, because the compliance costs will go up and many companies are already finding it too much. So Hong Kong is losing its competitive edge in many areas. Well, people would say that elsewhere, so long as there is a piece of legislation, I'll just copy it. So you're actually making things so difficult that it's like a straitjacket and people will find it difficult to operate. So I hope that the administration will face up to this and think about it. Okay, so please go back and think about it. Yes, Paul Chair. I also have to add, because I'm of the view that Mr. Chen Kin-po has suggested that we should not be copying from here and there, and as a result, the restrictions will be very restrictive. Because if there is very serious irregularities, then of course it's worthy of our while to tighten the net. But then, for example, in Hong Kong, for so many years we've been a free port, and our legislation should not be too tight. We are not in the Qin dynasty. So apparently you are trying to punish people before they even attempt to commit a crime. So I think there should be justifications before we tighten up the requirements, or else this is a free society, and if we tighten up everything, that's not our overriding policy, and that's not the spirit of the basic law, not even in the letters of it. So you should not just be saying that, well, A will copy from B and then B will copy from C, and as a result, every trade will see tighten up legislation. All right, please think about it. Chairman, thank you for your comments. So we'll consider it. But then I'd also like to respond. It's not that we are copying from other pieces of legislation. So when we enact legislation, we have to strike a balance between a host of factors. And one of the considerations is that there needs to be consistency. And if we are both committing an act which is very similar in nature and in different circumstances, if there are different levels of responsibilities, then we will also have to bear in mind this question of consistency. So there is no question of right or wrong. It's just where we strike a balance. So we'll go back and think about it, and then we'll give you a written reply. Mr. Raymond Wong? In the end, bracket 4 and 5 are actually the same. But then for the presumption of crime, whether it's with the consent or connivance of the person involved, or whether or not it's an omission or inaction on the part of the person. All right, on the one hand, you're talking about conniving an act, but then on the other, it's just that he has been negligent. So instead of using the plural form, of course, under the law, or are you referring to all the persons or just one or two of them. If he's just a director or manager or company secretary, that's why you talk about the individual. But then for the latter two circumstances, I think the level of liability is different. So would they both be breaking the same offense or breaking the same provision? So you're talking about negligence or inaction. All right, under 4 and 5, if there is any proof, then it's a criminal offense. So I'm trying to put down a footnote for those arguing about this. All right, this is a criminal offense. So you're talking about attributable to neglect or omission. Okay. 312, clause 123, time limit for proceedings for offences. So, under subsection A, the period of 3 years beginning on the date immediately after the date on which the offence is discovered by the authority, or B, the period of 6 years beginning on the date immediately after the offence is committed, whichever is the earlier. Mr. Raymond Wong, on the justifications for the 3-year and 6-year period. Chairman, well, after discussing with the DFJ, we have also made reference to some similar offences and the time limit for those. Because some might think that well, for the criminal proceedings, if it's if they're only instituted after such a long time, then that's not good. No, it's not that it will only be done after 3 years. So we are talking about a period of 3 years and a period of 6 years. Okay, so it could be 6 years, or else there is no need for you to put it down here. So it's the maximum period. So what are the justifications? Why 3 years and 6 years? Why not 2 years or 4 years? Why not 1 year? So why 3 years and 6 years respectively?
Chairman, generally speaking, when the IA discovers that some offence has been committed, it would collect evidence and initiate the legal proceedings immediately. But in some complicated cases, evidence has to be gathered and it takes time. In some ordinances, for example, magistrate's ordinance, the time limit is 6 months. So sometimes we provide for a longer time limit. If you say 6 months, and for a complicated case, evidence gathering requires more time, and if the time limit expires, and no prosecution can be carried out after that. So we are talking about complicated cases here for which we provide a longer time limit. I don't think you have really understood the focus of the question. They asked for why. He asked for why, not 1, 2, 3, not 1, 2, 5, 4 or 5 years or longer. He's not asking for a longer or shorter time limit, but just why? Why do you settle for 3 years and 6 years?
主席就呢一個咧係冇一啲。
But there's no hard and fast rule here that we must go for 3 years and 6 years. We make reference to similar laws, and that's why we propose 3 years. Again, you make reference to similar laws, and for which similar time limits have been set. Mr. Dennis Kuo, you may want to refer to limitation ordinance, for cases such as personal injury cases, it's 3 years. For normal civil cases, 6 years. Maybe it's a relevant consideration. But, well, the examples are civil, but here we're talking about criminal offenses. We make reference to other laws. We want to maintain broad comparison and consistency. Apart from consistency, will the government also consider the situation whereby the insured may take 1 or 2 years to discover that the policy or documents have problems? So it's really about the time one discovers the problem, and the company is required to keep records and documents for 7 years. If you have a longer time limit, then the company may have an excuse that it's difficult to comply and offer assistance. Don't just say that you copy it from somewhere else. Then members may not be happy. You must give some real justifications. Apart from consistency, you also have some policy considerations. Only by offering answers like this can you really satisfy members. Thank you for your comments. Apart from the question of validity of insurance documents, well, we don't set a time limit for people to lodge a complaint. Sometimes the policyholder only discovers problems when it's time for him to claim the benefits or to get the payment under the policy. This is a balance. If there's no time limit, well, of course, the law enforcement agency is supposed to take action as quickly as possible. There should be no delay or procrastination so as to adversely affect the relevant parties. So we make reference to similar laws, and that's why it's 3 years. We have another in the existing ordinance is 2 years. But in the newer ordinances, we have more cases where the time limit is set at 3 years. So we have considered those are the ordinances. I remember that in some cases, the authority found that the 2-year or 3-year time limit is too short. For example, in financial matters, there's a case involving the SFC. Mr. Albert Ho has talked about it many times. It's 8. It's about the offense having been discovered by the authority, or the case has come to the notice of the authority, and then a second limb is about 6 years from the time of commission of the offense. Records have to be kept for 7 years. And once the records are destroyed, you cannot really investigate the case thoroughly. Maybe you should set the time limit at 5 years. I think it will be more difficult for you to come back again once you discover that the time limit is too short. Well, Mr. Chan Kim-po hasn't spoken yet, but I just want to find some way in the middle ground. Apart from consistency, referred to by the Deputy Secretary, we have to bear in mind that in a criminal case, you may have to get a witness to testify and you have to prove the case beyond reasonable doubt, and memory is a problem for a witness. If it's something that happened more than 6 years ago, the witness may not have a clear memory, especially when you talk about what transpired in a transaction. And the 3-year or 6-year time limit is just for the time to initiate the proceeding. You may press a holding charge, and then you can seek to amend the charges if need be. Well, I believe this is a reasonable balance, the right balance. Commissioner, whether it should be 3 years or 2 years or 4 years, you cannot say one is wrong and the others are right. One is right, the others are wrong. We have a look at actual experience of investigations and initiation of prosecutions. Insurance business involves a lot of documents. And if there's an intention to commit an offense, it's sometimes not really easy to discover the case. And we're not talking about disciplinary offenses, it's criminal. So we think that we should take the opportunity to give the future authority more time to do its job. That's why we propose to increase the time limit to 3 years. If you ask why not 4 years, the Deputy Secretary has explained that we should go for consistency. But Mr. Chair is correct. That is borne out by our actual experience. We can initiate the prosecution within the time limit of 3 years. Very often we ask for extension or postponement so that the evidence gathering process can be completed. Honestly, there's no so-called ideal solution or a time limit. We want to give sufficient time for the investigation. On the other hand, we don't want the process to be too lengthy for the body or parties to be investigated. So we look at other laws and propose 3 years. There's no right or wrong answer here. We want the future authority. Well, will be subject to some restrictions on the time spent on an investigation, and that it cannot go on and on. But deferrals and extension of time is always possible. It's just a question of getting the right balance. There's no right or wrong answer in suggesting 2 or 4 years or 3. Mr. Paul Chair, what about Mr. Donald Zhang's case? 2012. It started in 2012. 3 years. It's just a short period. I think we have a very lengthy discussion. I just want to look at the wording A and B. A, after the day on which the day is discovered. And B, beginning on the day immediately after the offense is committed. But what do you think that the offense has been committed before the court has given a ruling? Mr. Chair, it's just an alleged crime. Mr. Chair, I think Mr. Wong Yong-man is better at Chinese language. Yeah, so a conviction is, of course, only after is a conviction only after the judge has delivered a judgment. But if you have they cannot write alleged crime. That's not how the terms are used in law. They cannot use the term alleged crime. I believe the two members have offered the explanation asked by Mr. Ng. 124. The authority may prosecute an offence under its name, and the offence may be tried before a magistrate as an offence that is triable summarily. An employee of the authority who is not qualified to practice as a barrister or a solicitor may also appear and plead before a magistrate, and the section doesn't derogate from the powers of the S.J. in respect of the prosecution of criminal offences. We have strong views about this provision. The DOJ has said this time and again, that when it comes to people who are not legally trained or legally qualified, and if you ask them to be the prosecutor, it's really outdated. Here we're talking about lay prosecutors. It's suggested that this should be phased out. Now for this important bill like this, you should not rely on an old system. In the future, the DOJ would like to make sure that all prosecutions are carried out by solicitors or barristers. We shouldn't rely on lay prosecutors at this day and age. Who would like to respond to this question?
Chairman, I fully share the view of Mr. Kwok. And in the light of Mr. Kwok's view, we have actually taken this up with the public prosecutor of the DFJ. So basically we share with that, and therefore we have already reached a consensus with the DPP. That is, upon the establishment of the IIA, there will be a memorandum signed with the DPP on the prosecutors' training and their qualifications. So the DPP will have to be consulted, and only upon his satisfaction will we be implementing Clause 124. So that's the result of discussion with the DFJ. So I fully share the view of Mr. Kwok, but then if we can keep this prosecution power within us, there might be some advantages. For example, for the less serious crimes, if the regulator can take up prosecution on its own, that might be more expeditious, so that there would not be a very huge case backlog. So it's after such considerations that we have come to this conclusion. But then I have to reiterate that I fully share the views of Mr. Kwok. Chairman, my concern would be even stronger, because you said that there will be a memorandum being signed, and then in 5 years' time you'll be reviewing the situation whether or not you'll be invoking 124 again. No, that's not true. In fact, when we discussed with the DPP, the Director of Public Prosecutions, we said that upon the establishment of the IIA, we would sign a memorandum with the DFJ, that is, in invoking 124, in taking out prosecution, the IIA would have to do something, including communicating with the DPP, and also for the qualifications and experience of the prosecutors and so on, they need to have undergone sufficient training. Well, Chairman, still I think that at this day and age, all criminal prosecutions in Hong Kong should be carried out by those with legal qualifications. And given the fact that this is also the policy of the DFJ, I don't think that given the fact that this is a very important piece of legislation, we will still have such outdated provision. I don't believe that in Hong Kong, if you were to take out prosecution, the IIA can always hire in-house lawyers to do the job. In many public bodies or statutory bodies, they are already doing this. So that's point number one. For example, the Estate Agents Authority. So for the Estate Agents Authority, they're doing the same. So they would hire qualified people out there, or you can also brief out the case. You can even ask the DFJ to do it. So there is no need for this to be done. So I don't really want to see this in this piece of legislation. This is a really very outdated provision. If you look at other common law jurisdictions, they no longer use such lay prosecutors. In the past, that there was a shortage of qualified lawyers. That's why they have to rely on lay prosecutors. And in this day and age, there is no need for you to do that again. All right, Mr. Kwok has very strong views on this. Yes, Mr. Sin Chung. Yes. Mr. Porche, I'm a practicing lawyer. That's why I have to declare interest before I speak. I fully share the view of Mr. Kwok. I support his views because initially, when we did not have legal professionals, that's why we had to have inspectors doing the prosecution. That's a long history. So, by the same token, they know it very well. In particular, we have already got many young lawyers. In fact, there is an excessive supply or oversupply of young lawyers. That's why I don't think there is a shortage of lawyers doing the prosecution job. And therefore, I don't understand why you have this very outdated mindset. And of course, I understand that even for the Privacy Commissioner, he would like to take out prosecution in his own name. And he has fought for this for a long time. And now the IIA does not need to fight for that. But then we have to strike a balance. Well, for an enforcement agency responsible for investigation, there needs to be a check and balance so that an investigator should also not be making all the decisions in taking out prosecution. I think that's a very important principle in the laws of Hong Kong. And that's also why we need to have the involvement of the DFJ and other legal professionals, whether it's a solicitor or a barrister, so that the code of practice would also regulate his acts. And number three, well, under 124, you again use the word barrister rather than counsel, because under 121, you use the word counsel. So even within the same piece of legislation, you have two descriptions. So is it that when you copy that, you copy this from a particular piece of legislation, and then here you copy it from another piece of legislation? Is that the case? Who is to answer this question? Chairman, as I said just now, concerning members' views, I don't disagree. It's just that we have to balance several considerations. And here there are two issues. In particular, if you look at 124, actually 124 is about the IIA, which can prosecute an offense. And then 124 bracket 3 says that even if the prosecutor does not qualify as a barrister or a solicitor, he will still be able to take up prosecution. Well, to require professional lawyers to do the prosecution, in fact, you're referring to 1243. I understand members' sentiments. I'd like to make it clear that concerning 1243, if you have a view, so are you disagreeing with the point about the authority taking out prosecution on its own? Because in considering members' comments, we also have to understand that for many law enforcement agencies, they have the power to take out prosecution. According to my understanding, in some common law jurisdictions, for example, in Australia, the relevant regulator also enjoys such prosecution powers. From what I heard from Mr. Kwok and Mr. Chair, concerning the prosecution power by the authority, well, they have no qualms about that at all. And the thing is, within the authority, for the persons responsible for prosecution, they have very strong views about their qualification. Is that right? All right, if you do not accept my comment, then I might move a CSA to delete this provision. All right, please listen to Ms. Sito first. Sorry, speaker's not coming through. In fact, I believe that the IIA would be inviting an in-house lawyer, as Mr. Kwok just suggested. There should be no problem. I don't think there would be financial difficulty. So I do not understand why you have to keep this provision. But then I'd like to ask the administration this. What is the existing practice in the past? Had there been any prosecutions, and what did you do? Did you engage legal professionals to do it? And if that is the case, then why do you have to keep this provision at all? Well, the Commissioner's office is a government department. That's why when it takes out prosecution, it has to go through the DFJ. But then in the future, the IIA will become an independent authority. That's why we have come to this conclusion. But then I have omitted to respond to a point made by Mr. Chair. That's about the barrister and counsel. The wording here. We'll go back and look into that. So we will be aligning everything to make sure that it's consistent. Ms. Sito, with regard to the prosecution power by the authority, I don't have any qualms about this. But then at present, you have the DFJ doing the prosecution, which is legally qualified. Then in the future, you should not be going back. You should continue to make sure that you will only have legally qualified persons doing the prosecution. So I support the suggestion made by Mr. Kwok, that is 1243 should be repealed and deleted. Mr. Paul Chair? Well, on your question, I'd like to clarify my stance. Basically, concerning the authority's future power to institute prosecution without going through the DFJ, I have some reservation. But then under the circumstances, in particular, for some statutory bodies and regulators, they would all ask for such powers in order to make it easier for them to do their job. But then, in appointing a barrister or a lawyer to take out the prosecution, if there is no such safeguard, then that would render my reservation stronger. So I would not agree to that. So I think the balance to be struck is that if we allow the statutory body to institute prosecution on its own, then it has to be done by legally qualified persons, because they are professionally qualified, and because of their own code of conduct, there would be better safeguards for the persons to be prosecuted. I think that would be the balance. Mr. Raymond Wong? Well, when the authority takes out prosecution, I think the controversy is in bracket 3. But then for bracket 4, would that be superfluous, because this section does not derogate from the powers of the Secretary for Justice in respect of the prosecution of criminal offences? What does that mean? How can you derogate from the powers of the Secretary for Justice in terms of his powers in taking out criminal prosecution? Well, under the Basic Law, we have this provision saying that the S4J will be ultimately responsible for public prosecutions. That's why 124 bracket 4 is to respond to the requirement under the Basic Law. On 124, I think members have raised their views, and the main concern is on bracket 3. So, admin, please think about it. I believe that it's very easy to resolve the problem. So you can have some internal or in-house lawyers to do the prosecution, and if that can be done, then all the problems will go. So in the end, if the administration is not prepared to move any amendment, then some members of this Bills Committee might be moving their own CSAs. So please think about it. Under the circumstances, would you like to resolve the problem in conjunction with members by moving an amendment instead of them moving this amendment? So on 124, so much for it. Let's move on. 313.125. So it provides that when a written notice or direction or other document is to be issued or served, it can also be done by fax or in electronic form. Move on. Next, 315, clause 126. The background is that in terms of the finances, the IIA will be separated from the administration, so it would be financed by the prescribed fees and levies on the intermediaries and so on. So 126 provides that the Chief Executive in Council may make regulations on the fees and charges to be imposed by the IIA. And 126 bracket A provide for the payment to the authority of and the prescribed fees, and also it says that the Chief Executive in Council may by this provision prescribe other regulations. Any questions? Next, subsection 2 says that for the regulations made under this section is not limited by reference to the amount of the administrative or other costs incurred or likely to be incurred by the authority or a committee established under this. And now on page 316, bracket 4 says that the authority may recover the amount of any fees payable under the regulations made under this section as a civil debt due to it. And then subsection 7 provides for the maximum penalty, $500,000 fine and imprisonment for 2 years, and if it's a summary offense, then it's a fine at level 6 and imprisonment for 6 months. Next. Yes, Ms. Sito. I'd like to ask about 126 bracket 3C. What may provide that the payment of any fee is waived, either generally or in a particular case. So for the particular case and also the general case, what do they mean? So the payment of any fee can be waived either generally or in a particular case. So because they talk about the general case and a particular case, I don't know either. Well, for general case, there should not be any exemption at all, because you're talking about general cases, and if that is the case, then you would not have introduced the fee in the first place. So I don't really understand. So I would have thought that the payment would only be waived in a particular case. But here you talk about either generally or in a particular case. What does that mean?
主席，我諗咧就即係呢個係純粹喺呢一啲。
Here we are talking about the flexibility in the regulation if a waiver is to be offered. And if you ask whether we have waived a fee after we have set the fee at a certain level, well, there may be some outdated runoff business of some organizations. The business has ceased, but still is in existence because of certain requirements. So the fee for that organization may be waived. So if we allow a waiver, it means that we have the flexibility. Otherwise, we cannot really do it. All right, so you just want to retain the flexibility. Mr. Paul Chair, bracket 7. You're talking about failure to pay a penalty or the payment is late. And then under bracket 7, it can be an indictment, a fine of $500,000 and imprisonment for 2 years. But for the for 124, bracket 2, the offense must be tried before a magistrate, and now it seems that the supplementary matter is even more severe. So have you really make it too strict? This is just a maximum penalty. The actual penalty depends on the severity of the case, the amount involved, and the circumstances. We may be talking about fees payable by big insurance companies. So is the supplementary matter becoming more serious than the underlying cause? Well, that depends on the circumstances. Usually you won't get the maximum penalty. Yes, there are criminal matters which would attract 2 years of imprisonment. So the offense must be tried before a magistrate. But for this offense, you can go to the High Court in theory. Well, why is it that you make it a rule to try an offense before the magistrate, but here you can take the case for non-payment to the High Court? I think Mr. Paul Chair was referring to 124. Bracket 2. Well, this is for offences prosecuted in the name of the authority. But for more serious cases, it will be carried out by the DOJ. So it's not the case that all offences will be tried before a magistrate. It's just for cases prosecuted in the name of the authority. For 126, it's an empowering provision. C in council will be empowered to make regulation. And also for bracket 7, the C in council may prescribe in those regulations a maximum penalty. But it doesn't mean that in all the regulations made under this particular provision, the maximum penalty would be as you see in bracket 7. 127. It authorizes the authority to make rules for prescribed matters. Please note that the rules are subsidiary legislation subject to scrutiny of this council under 1271A to O. There are some examples of the rules that can be made, for example, in relation to asset limit and debt level, and also the fund and the use of such funds for long-term business and how the funds are to be calculated. And in bracket O, the IAA may prescribe other matters under the rules or under this ordinance. Let's move on to 128. It's page 319. The authority. I have a question about subsidiary legislation. Is it subject to negative vetting or positive vetting? Negative vetting. Please continue. 128. The authority may, where appropriate and subject to consent, relax certain rules on the basis that first, it will not contrary to the interests of policyholders, and B, it will not adversely affect the authority's ability to carry out its functions under the ordinance. And the authority must publish a Gazette notice to the effect as soon as practicable. 129. In the rules set by the authority, it may specify that certain matters, certain provisions are not applied to certain specified persons or in a limited way only. And the relevant persons or parties are set out in the subsections. 130, it said that the authority may make rules. Under 130, the authority must, through suitable means, invite public comments on the rules, on the draft rules, and the authority must also publish a report to set out the representations made on the draft and the response of the authority to the representations. And if the rules made are significantly different from the draft, the authority must publish in a suitable manner details of the difference. 131, the authority may publish in the Gazette or in other manner it considers appropriate codes or guidelines that it consider appropriate for giving the guidance to the trade so as to facilitate compliance. Under 131(4), a failure on the part of a person to comply with the provisions set out in a code or guidelines does not by itself render the person liable to any judicial or other proceedings, but however the code or guideline can be admissible as evidence. And under bracket 7, a code or guideline published under this section is not subsidiary legislation. And 132, order to impose orders and regulations for levies. The Sitting Council may, by order published in the Gazette, specify a levy, and the levy may be expressed as a percentage of the premium payment or fixed amount or in any other manners. Mr. Alan Leung, I want to return to 131. I want a clarification. Under bracket 5, it said that, however, in any proceedings under this ordinance before court, the code or guideline is admissible in evidence, and B, if a provision in the code or guidelines appears to the court to be relevant to a question arising in the proceedings, the court must, in determining the question, take into account any compliance or non-compliance of the provision. I want a clarification. If a regulated person, a regulated party, has been adjudicated by the IAA to have breached certain code or guidelines, the ruling, the adjudication ruling, will be submitted to the court, and the judge would look at the ruling to determine whether the onus of proof has been discharged by the prosecution. Well, the intent here is that the authority can issue code or guidelines, and which are subsidiary legislation. But such code or guideline is not subsidiary legislation. The code or guideline is issued to facilitate compliance by the trade, and the code or guideline reflects how the authority interprets statutory or regulatory requirement. So first of all, these codes or guidelines are not a subsidiary legislation, but they do have evidential value. As I've said, the code or guideline reflects how the authority interprets the regulatory requirements. Let me ask a follow-up question. If you invoke the insurance company's amendment bill or ordinance, and then you initiate prosecution, and the background is that the authority has ruled that the accused or the alleged offender has breached certain code or guideline, will the onus of proof be the reverse, and that is from the prosecution to the defendant? It's not very clear here that the court may take into account any compliance or non-compliance of the provision. But what is the effect of doing this? What's the effect on the onus of proof? Deputy Secretary, the policy intent is not to reverse the onus of proof. Where there's a prosecution, the onus is always on the prosecution. Or if necessary, we can take this up with the DOJ to see how this can be clearly reflected in the law so as to address Mr. Leung's concern. I have a question for our legal advisor. We have heard the policy intent from the Deputy Secretary. What does our legal advisor think about the drafting of 1315 as to whether it fully and accurately reflects the policy intent? Under 1315, the way it is drafted, well, if you ask me whether it has the effect of reversing the onus of proof and pass it on to the defendant, I don't think that's the effect.
However, in terms of the drafting, can the administration make it more clear? And then I can take it up with the DOJ again. All right? Chairman, I'd just like to put on record my concerns, because the way it is put here, that is when the court makes a ruling, it will have to make consideration to the compliance or otherwise of this. I think that's pretty vague, because here you talk about the court having to consider this. So the court must consider. So according to the legal term, well, there is an evidential importance here, because in English you use the word must. So in the course of consideration, how is the court expected to do its job? So in assessing the arguments put forth by both the prosecution and the defendant, so to what extent must this be considered? In particular, in terms of the evidential consequence, I'd like to know a bit more. Well, it's already time, so Mr. Chair, can you be brief? So we can extend the meeting by a small margin. Do we agree? All right, I agree that there is this doubt, and I agree with the legal advisor in the sense that with regard to the onus of proof, it might not have been passed on to the defendant. But then what I'm concerned about is, well, let me look at it from another perspective. If the prosecution has to institute this prosecution, so does it have to refer to a decision taken by the authority with regard to the non-compliance by the defendant instead of having to go to individual witnesses before getting the witness statements and so on, as Mr. Alan Leung just said? Evidentially, if this is something that has to be considered, because it's a must. So whether you're smart or if it's a smart prosecutor, then so long as he can rely on a decision taken by the authority concerning the non-compliance by the defendant of a particular rule, then that's the case. And there is no need for any interrogation and so on. So that's already the established procedure. And if that is the case, then the defendant would be disadvantaged in terms of the evidence. I think that's one of the worries of Mr. Leung. I agree, this is my concern, says Mr. Leung. Okay, so shall we leave it to the next meeting? Okay, date of next meeting, 7th of May, Thursday, 8:30. And we have another meeting on 11th of May at 10:45, it's a Monday. All right, so we are now on 131, and there are still some queries. All right, that's on page 322. If there is no other business, then our meeting is now adjourned. Thank you.